All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us for effective communication for deaf and hard of hearing individuals, legal requirements, and best practices. Before we pass it over to our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you registered, you're going to receive an email within about 24 hours with a link to the recording, a link to the materials, the CLE code, and some additional information about the public interest law section and the Florida Statewide Training Initiative. It will also be posted on YouTube, so if you want to share this information with others, you're also going to be able to find it on YouTube later. This webinar was approved by the Florida Bar for 1.5 general CLE credits, zero point 0.5 professionalism credit, zero point 0.5 technology credit, and zero point 0.5 ethics credit. I'll announce the CLE code towards the end of the webinar. I will drop that CLE code in the chat. That CLE code is also going to be in the email that goes out from Zoom, and you will also be able to find it in the YouTube description as well. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility or the captions, feel free to reach out to me directly. For questions, if you have questions during the presentation, please, you can use the chat or the Q&A. We will try to address questions as they come in. And for whatever reason we miss a question, we'll make sure to address that question towards the end. So I mentioned the public interest law section. So this training is being co-hosted by the Public Interest Law section, or PILS. So if you're not familiar with PILS, I highly encourage you to take a look at our website. I'm going to drop all these links into the chat as well. It's bar fee season. You probably got that email from the Florida Bar, and that's a great opportunity if you're not a member to consider becoming a member. Two birds, one stone. We probably have one of the lowest fees out here in Florida, and we have a lot of CLEs. So we do a lot of great work, and one of the most active work groups that we have at PILS is the Civil Rights and the Immigration Work Group led by DJ Neary. This work group, they meet monthly on the fourth Tuesday at noon. They really did the heavy lifting putting together this webinar, so I have to give a lot of credit to DJ, Lee, and everybody in the work group. They do such a great job of organizing these webinars. They have monthly meetings where they bring guest speakers to come in, and they make my job a lot easier because they do the heavy lifting when it comes to recruiting speakers. So with that said, before we pass it over to our speaker, I'm going to pass it over to Sharon Langer to be able to introduce our speaker. So Sharon, the floor is yours.
Thank you, Jorge. I'm very pleased to introduce Matthew Dietz. He is a nationally recognized civil rights and disability rights attorney with more than 30 years' experience litigating complex cases under the ADA, the Fair Housing Act, and Section 504 of the Rehabilitation Act, both state and nationally. He is a former director and professor at law of the Disability Inclusion and Advocacy Law Clinic at Nova Southeastern College of Law, where he led high-impact litigation and trained future lawyers in disability rights. Mr. Dietz has been accepted as an expert in disability, compliance, accessibility, and has worked extensively on matters involving effective communication. His work focuses on translating legal requirements into practical strategies that ensure meaningful access while addressing real-world operational challenges. And I think that's what you're going to get today, is that ability to take practical strategies and ensure meaningful access. Through DISLAW Consulting LLC, Mr. Dietz provides specialized consulting, training, and expert witness services to attorneys, healthcare providers, governmental entities, and private organizations who are trying to navigate disability-related legal obligations. DISLAW Consulting collaborates with trial counsel in complex litigations, including personal injury and medical malpractice, and ensures that disability is fully understood and properly integrated into case strategy and damage analysis. We are really fortunate to have this expert with us today. And with that, Matthew, I'll turn it over to you. Thank you.
Great. Thank you so much. So it's great to be here. Always great to be with PILS. I was chair back in sometime in the 20th century. And this is a topic that I have been doing a lot of work on over the past 30 years since I was with PILS, since I was president of PILS. But today we're going to talk about effective communication for deaf and hard of hearing people. This really is an interesting topic that not many folks know about. What to do when you have a deaf client. What does it mean to be deaf? How do you accommodate a deaf client? So the learning objectives that we have today are, first, understanding what the legal standards are. Then to evaluate auxiliary aids and services. What do you use? What is effective? What is not? Analyzing interpreter qualifications. All interpreters are not the same. All ASL interpreters are not the same. Apply best practices. How to have interpreters, how to represent somebody who is deaf in court. And lastly, assess litigation exposure. What is the likelihood that someone is going to be sued for a violation of language rights, of the ADA with regards to language rights? Now, the first issue is, first, being deaf, communicating in sign language is not like English written. There is a deaf culture. People refer to that as big D deaf rather than little d deaf, which refers to just the physical limitation of not hearing. And the question is, why is language so important? Why do you need to have a sign language interpreter? Well, primarily, a sign language interpreter is important, and language access is important because most deaf children are children of hearing parents. So parents should learn how to speak ASL, but only 1 in 4 hearing parents of deaf children learn ASL. So if you think about all of the language you get from your family, from TV, from reading the newspaper, from going to school, all of those different ideas and different ways of speaking and different terminology. A lot of folks that are deaf do not get that same input. So as a result, the average reading level for a deaf person is about 4th grade, but with wide variation depending upon the location, where they live, their parents, whether they're part of the deaf community. So the first thing is lip reading. Lip reading is not effective in general because only 30 to 40% of spoken English is visually distinguishable on the lips. So, for a person that does not have an underlying understanding of English and spoken English, lip reading doesn't help that much because a lot of how your mind works in your visual processing of, audio visual processing of speech is some people only hear certain things, and because they hear them so often, it fixes those gaps that people have with regards to language learning. Now, the deaf-not economy. Deaf culture is different. So there's some things that that deaf people do as a cultural thing, such as the deaf nod. The deaf nod is when a deaf person just nods, and it doesn't mean that they understand what you're saying. They acknowledge that you're saying that. And it's very important to understand the importance of ensuring effective communication. So let's go to the next slide, deaf history. Sign language has been around for a long, long time. Every country has their own sign language. They have local variations of sign language depending upon where they live, what they do. Now, Lauren Clerk was a teacher of French Sign Language who came to the United States, hired by by Gallaudet to be the teacher of his daughter. And from that, the American Sign Language went forth and continued to teach American Sign Language to a greater amount of people. Then at the same time, you have Alexander Graham Bell, who is the dude to the right. Alexander Graham Bell had a wife who was deaf, and he believed in oralism, which basically means that deaf people should assimilate into society and learn how to speak and do it as best as they can. This debate came to a head in 1880 in the Conference of Milan, and during that time also was the issue of social Darwinism, the rise of eugenics, which focused on the ideal healthy person. And at that conference, they decided to promote oralism, and a lot of places banned American Sign Language. So that was the standard of education for years and years and years. And I still have some clients that remember when they were kids and they wanted to sign, their hands were slapped and told not to. Civil rights movement. The deaf civil rights movement preceded the ADA, and Gallaudet, which is the oldest school for the deaf in the United States, they were very upset because for 100 years they had hearing people that would lead them, and they felt that somebody who is deaf should be part of the leadership of their school and should be in leadership in everywhere in the United States. Being deaf should not be a limit to what you can do. So when a deaf candidate, I. King Jordan, who is again the dude to the right, was one of those finalists that for the presidency of Gallaudet, they picked a hearing person. And this caused widespread protests, and finally, I. King Jordan became the president of Gallaudet. So this was in 1988. So in 1990, the ADA was adopted, which fully included the right to effective communication within the ADA. And in the speeches with regards to enacting the ADA, finally passing the ADA, there were one of the senators even did a speech in recognition of his brother, who is deaf in sign language. But it didn't stop there. The issues for deaf not only are in the United States, they're also internationally. And the Convention on the Rights of Persons with Disabilities of 2006 recognized deaf people as a linguistic and cultural minority with enforceable rights to use, access, and have recognized their sign language in all aspects of life, including education, communication, and participation in society. As I said earlier, the big D, which is deaf culture, a lot of deaf people have deaf groups, deaf social issues, they marry deaf people. It's in effect an insular community based upon language and based upon their own built culture. There are three nations that were not signatories on the Convention on the Rights of Persons with Disabilities, and that is Syria, Cuba, and the United States. Equal language access. What does the civil rights laws require? Equal language access. So this is what the ADA and this is what the regulations behind the ADA state. A public accommodation shall take those steps that may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services, unless the public accommodation can demonstrate taking those steps would fundamentally alter the nature of the goods, services, facilities, privileges, advantages, or accommodations being offered or would result in an undue burden. That means a significant difficulty or expense. Now, several things worth noting. It is an affirmative duty to ensure that no individual with a disability is excluded. Courts have required a request, but it is also an affirmative duty. Now, let's talk about what it means. What does effective communication, ensuring equal language, what does that mean? Well, this is the Silva case involved a woman who was giving birth at a Baptist hospital. And when she was going to the birthing classes, they said that they wouldn't provide her an interpreter to communicate. And in that case, Silva versus Baptist Health South Florida, which is the seminal case with regards to effective communication, it defined it. The relevant inquiry is whether the entity's failure to offer an appropriate auxiliary aid impaired the deaf person's ability to exchange relevant information with the entity's staff. So the position of the defendants in that case and the appellees was that as long as the deaf person has a basic understanding of what they need or what they can do, that's all we're required to do. What the court held and what the plaintiffs pushed was a person who is deaf is entitled to have their right to understand anything that a person who is able-bodied, who can hear, obtains. So as long as it's relevant, a deaf person has the opportunities to understand, especially in medical environments where it's really, to not provide language access is to deny medical choice. Now, the issue that's of importance and equal importance, that's why they're all one, is what do you need? What is the difference between passing notes and having a specialized interpreter? And it depends upon the person. It depends upon the situation, the length, complexity, and importance. So those are the three factors. Is it a lecture that is what I'm doing now for an hour? Is it, that you would need an interpreter. There's no way that you can get that from passing notes or text messaging. Definitely not lip reading. With automated captions and live captioning, you could probably do it. But it depends upon your language. Complexity. The more complex something is, the more you need it. You need it. An interpreter there. I'm sorry. It just got away from me here. Okay. The more you have, the more complex it is, the more you need an interpreter. What an interpreter does is, an interpreter does not merely translate. An interpreter is able to take complex issues or complex ideas in English and be able to translate them, especially when it's not a word-for-word translation. The more important something is, the more you want to ensure that what they're getting is absolutely perfect, that every single word they understand so a decision could be made. So when you look at the lower part of the scale, passing notes would only be good in some place like you're at McDonald's and you want to order something and pointing at the overhead menu just isn't doing for it. Or you're doing something in through a drive-through, which maybe at that time you may want to do the text messaging if there's a way to text message. Lip reading, hi, how are you? Very similar pleasantries, nothing important. Now, captioning automated captioning, which are your normal AI YouTube captions, or live captioning when you actually have a court reporter, similar type person, typing up every word. They're good for folks that have a very good working knowledge of English, not the typical person who has a fourth grade knowledge of English. Not something you want to do. Video remote interpreting, we'll go into what that is in a little bit, where you have a interpreter static on a post, a single live ASL interpreter if something is relatively short, team ASL interpreters, that you need a team when something is approximately an hour long, so you have two interpreters to switch off every 20 minutes so they don't get fatigued, and a CDI, which we'll talk about in a minute, which is a deaf person that breaks things down further, so people that have lower English understanding skills will be able to understand. So when we look at what is an interpreter, what is a qualified interpreter, let's look at this. Oh, I'm sorry. So what she's doing here, even though you probably can't hear it, is she's interpreting them. As you see, it's more than just plain static interpreting. Interpreting sign language and speaking sign language is a 3D. It's body language, it's the use of space, it's the use of your face, you smile, your expressions. All of it is needed, especially when you do items that include a lot of this type of emotions important, because what she's doing is she's not only interpreting the words, she's interpreting the feeling, she's interpreting the music, she's interpreting the attitude. All of these things are included. Like that off. Turn this off. There we go. And one anecdotal story about that. Oh, now I just messed up the whole thing, didn't I? From current slide. Here we go. Here we go. An anecdotal story about that is when I was in trial once, actually in a case called Fuller versus Fuller. And in Fuller, my client was so upset he went off of the bench and said asshole in sign language. And he made a sharp turn of his arm. So the interpreter did it just like it would be in English, and the interpreter screamed asshole in the middle of court. And Judge Donald Graham did not like that too much. So let's talk about a CDI. What is a CDI? And I said before, it's somebody who breaks things down for a person who has a lower language skill. So a lot of folks, well, not a lot of folks, some folks that are deaf have minimal language skills. For example, if they grew up without any access to language, any access to deaf people, with poor educations, they have minimal language skills, and sometimes the language skills are so low that they are what's deemed linguistically incompetent, which means they cannot be tried. They cannot understand what the court proceedings are. They can't assist it in their representation. So a certified deaf interpreter is a deaf or hard of hearing person who is specially trained and credentialed and licensed to be able to convey meanings for the deaf and hard of hearing individuals. These are used more frequently you'll see in emergency broadcasts, where emergency broadcasts, the person who's interpreting that you usually see is a CDI, certified deaf interpreter, and not a hearing interpreter. And if opposite from the CDI by the camera is usually the deaf person that the CDI watches in order to break it down as much as possible for TV viewers. Now, the other issue, which is a controversial issue now in effective communication, is what type of interpretation, what type of information is, what do you use? Can you use the auxiliary aid of a video relay interpreter? And what is a video relay service? Folks get that confused at times. A video relay service is the phone a deaf person can use. They don't have a normal phone. They don't use TTYs anymore. They use video relay service. Video relay service is free, and it's paid for by a surcharge on everyone's phone bills. So what happens is the person who is the deaf person, two types, can either connect with another deaf person or connect with a video relay operator that connects with a hearing person by the phone. So that is what video relay service is. It's much different than video relay interpreter. A video relay interpreter is a interpreter on a pole, essentially, which they use a lot in hospitals and some other areas in which the communication is usually not emotional, usually static, like office information where you're sitting there, the deaf person is sitting there, there's not a lot of movement, it's not emotional, it's straight interpreting. Now, why does that make a difference? Now, here's a chart which compares video relay interpreting and live interpreters. The problem that you have with video relay interpreters, if you don't have good internet access, it just lags, it doesn't work, it freezes, it's frustrating, it's not effective. More people in the room. It's not effective for multi-speaker settings. So let's take something like when Shayla Silver was going to give birth at Baptist Hospital. If you look at a video relay interpreting, even at its best, where do you aim the camera? Where do you, if there's different doctors and different nurses and different staff people, who is the interpreter going to interpret? How is the deaf person going to know which person is speaking? If it's the nurse, if it's a doctor, if it's an anesthesiologist, or it's the mother-in-law. Having a video relay interpreting will not be able to discern that in which a live interpreter can. For example, a live interpreter could get underneath a person if they have to lie on their stomachs or on their knees, so you don't have to try to find a way for the video camera to be able to see the person who is deaf. So it is a way when you have a very emotional static it's when you have an emotional situation or a situation that's constantly moving or many different people that are speaking, it is preferable, if not required, to have an interpreter. Now, the other issue, as you saw by the interpreter who is interpreting Eminem, interpreter, the more active you get, the more that's happening, the more emotional it is, the more that you're going to need more of a 3D interpreter to adequately explain what's happening and to be able to have that space, have that use. And it all depends again on the type of the importance of the information, the type of information, and the length of the communication. Title II versus Title III. ADA Title II involves governmental entity. ADA Title III involves public accommodations. The requirements for them differ. Now, for ADA Title II, it's not a specific public accommodation. It is a program or service of a governmental entity. And in under Title III of the ADA, it is a place of public accommodation. For a theater, do you have an interpreter? Or should you have an interpreter for things that don't relate to the theater? What are the programs of the theater? So if you had a benefit that you got an audio tape for getting a ticket, do you have to make that accessible? No. The difference is in Title II, it's programs and services. Why is this important? There's many different examples. In a dependency case I had at one time, that the woman had her child taken away from her because of her speech disability and her other perceived disabilities. They didn't get an interpreter, they didn't wait, they didn't give her any accommodations. And with regards to their duties as child protection investigators, they had a duty to provide her all accommodations she needs. But then if you look at what the purpose is of the dependency system, the purpose of the dependency system is to ensure families are reunified with the services that they need in order to be parents. All the state does, well, the law contemplates that the state should do the greatest extent to get a family back together. Now, when you look at that and you look at where does effective communication fit in, you could think of all of the different types of ways that it fits in outside of the courtroom. It fits in with classes. Are your parenting classes accessible? Do they have them in sign language? It fits in with evaluations. It fits with meetings with the CPI investigators, meetings with the home study folks, being able to understand what's provided in home study. So all of these things are necessary for to ensure that there is effective communication in the program and service that is provided. And you could take that into other aspects. For example, let's say a person needs to go to a safe driving course after getting a ticket. That safe driving course has to be accessible to the person with a disability. So what would happen is if the driving course did not provide an interpreter, it would be the court's legal duty to ensure that their contractor provided an interpreter. So it not only applies to the system itself, the court system itself, but for anybody that any public entity contracts with and serves the clients of the governmental entity.
Hey Matthew,
Court,
we do have one question that came in through the Q&A, and I wanted to make sure we addressed it. So I'm going to go
yeah,
ahead and read it out loud for the benefit of the audience. The question is, my legal aid program follows DCF's trainings, which includes using a form request for assistance we provide to the applicant for services and indicate how best we may communicate with them. For example, ASL interpreter or other auxiliary device. Should we make an effort to discover their level language skills and if they may need a CDI?
great question. Great question. The answer is first, if they write they need an interpreter, you could provide it, but then you ask the person, is this okay? Do you understand? Is there anything else that you need? Most people that have a disability or are deaf know their needs better than what could be in a form. Now, it's also important that that accommodation is provided throughout and just not for some things and not others. But yeah, the DCF form is great. The DCF form was implemented as a result of a case years and years back where a 16-year-old was arrested for molesting his 5-year-old brother. The 16-year-old was entirely linguistically incompetent. He enjoyed watching VCR videos at the time, VCR, of cars crashing against each other and other things like that really language was not necessary. So once he was arrested, there was no attempt to communicate with him. He was sent to Chattahoochee to be rehabilitated. Of course, he could not be rehabilitated because he had no language skills. He stayed in jail for several months and a complaint was brought in front of HHS, and they got into a settlement with DCF requiring those forms and the training. Now here I got the question. Oh, okay. Here's a question. I'm reading the question now.
You have the question in the chat just for people to be
Oh,
able
that's
to
the
see
same
it,
one?
just in case.
Okay.
Yeah, it's the same question.
Courts and the deaf. Now, since we're talking about courts, the competency evaluations, so important. You have to have a competency evaluation with somebody that works with deaf clients so they could actually determine how competent, what is the understanding of the deaf person. Having a competency evaluation with somebody who does not understand sign language really will not be beneficial for your client. So there are several competency evaluators in Florida that frequently get hired by the courts to do these evaluations. Why is this important? The same thing that I was saying with this kid who was 16 who was molested. If the person is linguistically incompetent, they're not going to understand the proceedings at all. It is difficult in order to restore competency for somebody who's had a lifetime of language deprivation. Other things that you need with the courts: attorney-client communications. You need your own interpreter. You cannot use the courthouse interpreters in order to communicate with your client. Dependency issues. All of the deaf people need an interpreter with regards to that, but it's also very important, as I said before, that every step of the way, the deaf person, the companion of the deaf person who needs to be spoken to, is communicated in their own language. Voluntary and knowing waiver. This is something that's always bugged me, because whether it comes to a deaf person at a real estate closing, a deaf person signing a credit card agreement, or a deaf person waiving their rights in court or understanding a probation agreement. I mean, the rules of probation, which I've had several clients who didn't, because they didn't have an interpreter. Probation did not have an interpreter. So it was difficult for them even to know how to comply and what it meant to waive their rights. And captioning. Captioning is great, but again, it all depends upon the skills of the person who's deaf. So it's a challenge to have interpreters in the courtroom. Number one, they're expensive. A legal interpreter could cost as much as $150 to $175 an hour. For any court proceeding, you need 2 interpreters, you need a team, and you have to watch where you place the interpreters, because you can't block the jury's view, you can't block counsel's view, so you always have to plan ahead in what you need. Then on top of that, if you see there's an interpreter team too. So if you have 2 deaf people, if you have a deaf witness and a deaf litigant, you're going to need 2 sets of interpreters, because one is not going to be able to see the other. And the person who's the litigant, the plaintiff, has a right to know what's happening. And it's difficult if you are blocked, if you're on the other side of the room. When I've had trials with deaf people, I've actually sometimes, and I couldn't get 2 teams, I would have my client stand up and move next to the jury box in order to see what the interpreter was saying. Then on top of that, you will need a table interpreter. A table interpreter is the person that translates between you and your client. You cannot use the team interpreters to do anything attorney-client, because they are working for the court. And then on top of that, if you had people that were deaf in the audience, they have a right to understand as well. So again, they may need interpreters if they were going to the courtroom to watch what's happening. By the way, I did this with AI. It took an incredible amount of prompts, even for AI to understand. Request for accommodation. Request for accommodation. Now, one of the difficult issues is sometimes, because most people don't have training in the law, do not know what the process is for requesting an interpreter. Even if it is clear that the person speaks sign language, if there is no request for an interpreter, there is no obligation to provide one. And that is a horrible lesson that I learned. The next one, medical interpreting. Oh, this is a picture of Shayla Silver, the person in the Silva versus Baptist Health case. Medical interpreters' effective communication is particularly critical because it may lead to misdiagnosis and improper or delayed treatment. Yes, without a doubt. And the best way to determine whether or not an interpretation is effective is to have the clients repeat back to you what you said in their own understanding. It's something that doctors use often when ensuring that patients know what they're saying, and it's something that I've used often with people that are deaf. Employment discrimination. There was just a settlement that the EEOC received for a deaf litigant for $700,000 because he wasn't provided an interpreter during an interview. And they said because he was deaf, he couldn't have the job anyway. No, you're entitled to an interpreter, effective communication during the application and interview. You have to look to see whether hearing really does apply to the essential requirements of the job. And you have to go through the interactive process. There are things that you wouldn't even think about that you would say that, how can a deaf person do that? The deaf person knows better about what they can do and what they can't when it comes to a job interview. You could ask a person, how do you expect to communicate with people that call on the phone? And they should be able to tell you. You could ask them, how do you plan on you're a driver? How do you plan on communicating with somebody who is in the back seat? These are all things that deaf people do on an everyday basis, but it's important to ask because I am surprised with every new thing that I learn about accommodations that are available for people with any disability. So an employer really needs to go in with an open mind and could ask, okay, this job requires receptionist duties. How do you do it? Well, in fact, the White House receptionist under Barack Obama was a deaf woman. Fundamental alteration. Now, fundamental alteration is something that is used a lot when it comes to providing sign language interpreters for anything. Does it alter an essential aspect of the activity such that it would be unacceptable, even if it affected all participants equally? And number two, if it provides a disabled individual with an advantage over others, thereby fundamentally altering the program and service. There is not many people or not many things involving the deaf that would be a fundamental alteration. Possibly things that are in cramped areas that you could not have any interpretation services, or that things may become very difficult or dangerous. You could think of having a kitchen at a fast-paced restaurant with a lot of people, and and they need to be able to communicate in a way that's quick. Again, it's an assumption saying that that would not be possible because you could think of a lot of things that are repetitive, a lot of things that could be communicated in other ways, a lot of shortcuts that could be used, some sign language that could be taught to the staff. There's always ways to think about, is there a way that this is not a fundamental alteration? Undue burden is a little bit different. Undue burden, you look at several factors: the cost, nature, and cost of the accommodation, the overall financial resources, the impact on the operation of the facilities, all sources of outside funding. When we're talking about undue burden, it's very rare that a state entity or a governmental entity can claim undue burden, because they really don't have the money issue. Now, usually, and this is going to be something that is true no matter what you do, interpreters are expensive. There is not a cost-benefit analysis. If you're talking about an undue burden, you don't compare the cost of having a 24/7 interpreter with the person's job and the job responsibilities. It all involves the burden, the money that would affect the entity as a whole. So it's a very interesting issue that that is always used as a reason for denying an interpreter. One that's an issue that arises for many lawyers is, why do I have to pay $250 for interpreters for an initial consultation that's free? And the reason why is, you're a busy lawyer, you handle many people, you do all your consultations for free, you can't charge the deaf person, and you have to provide an interpreter. It is, no matter what you do, how you do it, you have to provide an interpreter if it isn't going to really cause you to suffer an undue hardship. Now, sometimes if it's a sole practitioner who works out of the trunk of their car, You can find some folks that it would be an undue burden, but it's really, again, a very high standard. Now, the problem that you have now, and this is relatively new, and I'll talk about this for a couple minutes, is the law is great in conceptually, but it's harder and harder to bring a case. So even though the law says what it does, and deaf people are entitled to effective communication, the only remedy you get under Title III of the ADA is you're entitled to injunctive relief. They have to provide interpreters in the future. But it's very difficult to satisfy the requirements for standing that you have to show a likelihood of future injury. It's not likely that somebody is going to go back to an acute medical center. It's not likely a person is going to get discriminated by the court again, and they're likely to go back to the court. So all of these things that it is not that you don't have a probable reason or expectation of going back in the future, you don't have standing. For things like employment, you do. It happens. You suffer damage. There is another whole section that you have to go through EEOC issues. You have to satisfy condition precedents. So you do get to do that in employment issues, but not so much in many other issues. And you also in housing issues, the discrimination occurs once once a denial is made, and that itself is damages under the Fair Housing Act. But under the Fair Housing Act, you're entitled to damages itself, compensatory, punitive, and attorney's fees. So you would maintain standing. But for Title III, you're just not going to do it. Title II is a little bit different, and Section 504 that is similar to Title II for equal opportunities for folks with disabilities. You're entitled to relief, but only for your actual damages. You're not entitled to any relief for non-economic mental pain and suffering damages. This is something that the Supreme Court decided in about 3 years ago now, and it was a case involving a doctor not providing an interpreter. Well, it was actually physical therapist not providing an interpreter, and the court held that as all spending clause laws, such as the Rehabilitation Act and 504 that was drafted to include the remedies of the Rehabilitation Act, that does not include non-economic damages because of the fact that it is premised on the contract clause, and you can't get non-economic damages under the contract clause. So you're not going to be seeing many claims for items in which injunctive relief is the only relief available, unless it is an ongoing problem with that individual. This is my contact information. My website isn't up yet. It should be up within the next month. And if anybody has any questions, I'm more than happy to answer any questions that you may have.
All right, so I'm looking at the chat. I don't see any questions, but to give people some time to be able to ask questions, I'm gonna go ahead and pull up the CLE code and drop it in the chat. I'm also gonna go ahead and read it out loud. So the CLE code for this one is 26042770N. So I'm gonna go ahead and drop all this information in the chat as well. It will also be sent out via email, and it will also be included in the YouTube description. I'm also going to go ahead and drop a link to the materials as well. And while I look them up, let me see. There's a question that came in. It's in the Q&A, and the question is, Do you fear that AI may take the place of ASL in court hearings? And that was one of the questions that I had. So,
The question is it going to be effective? It's going to be similar to the video relay interpreting, and and that's a hot issue now with the deaf community. What is AI going to do? I don't think it's ready. I don't think it would be effective. I wouldn't trust it for sensitive legal ideas. And until courts accept AI filings without doing these order sanctioning lawyers, I wouldn't trust AI that much. So it's only as good as the algorithm. So probably in 10 years, it is going to be something that can be used. Please use those charts. Those charts are great when thinking about what is and what is not effective communication, when VRI is effective communication, when it's not effective communication. A lot of deaf clients will say, I'm entitled to a live interpreter, and it really is a case-by-case determination involving the importance and length and complexity of the information provided. Now you're silent.
thanks for letting me know. Yeah, I'm looking at the chat to see if there are any other questions. I dropped the materials in the chat. I see a few questions. Let's see. I see a lot of thank yous, excellent presentation. And I do see a comment from Cheryl that the firewall prevented the download. Cheryl, feel free to email me and I'll see if I can email you a copy of the presentation directly. Typically, what I do is I set up a shared folder and drop the materials and the COE certificate into the folder. But I'll make sure that if anybody has any issues accessing the documents and the materials, let me know and I'll try to email them directly until we figure it out. But yeah, I see a lot of thank yous. Matthew, thank you so much for coming in and
Thank you.
sharing all of your knowledge and expertise with us. A special thank you to the Civil Rights and Immigration Workgroup with Pills, DJ, Leah, Sharon, everybody that put all of this together. This is a very much needed presentation and a must have in the toolkit for any civil legal aid and public interest law member. So thank you again, Matthew. Make sure to look at the Pills website and to look at the work group. Because if you're not a member, consider joining. Joining that monthly meeting is a great opportunity to come up and discuss these type of topics and emerging issues. We always have ongoing emerging issues happening, and how can we and that discussion and how we can address those emerging issues is key. So I know we're early on time, so I guess everybody has a big chunk back of the day. So thank you all again for joining us and have a great rest of your day. Thank you again, Matthew.